A seismic shift is underway in the United Kingdom's immigration landscape. In 2025, the government unveiled a white paper restoring control over the immigration system that proposes the most significant immigration reforms in a decade. The most notable and contentious of these proposals is the potential doubling of the qualifying period for indefinite leave to remain, ILR, from 5 years to 10 for many visa holders. This has sparked widespread opposition, with thousands contesting the plan, citing concerns over increased costs, potential family separations, and negative impacts on hiring. As current visa holders grapple with the uncertainty of their future, the government has indicated that a consultation will take place later in 2025 before any final decisions are made. This article will delve into the heated reactions from the public and members of Parliament, explore the key concerns for families and the economy, and consider the fundamental question: are we witnessing the end of UK immigration as we know it? On May 12, 2025, the UK government published its white paper outlining a series of major changes to the immigration system. The headline proposal is the extension of the ILR qualifying period from the current 5 years to a new 10-year standard for most visa categories, including the skilled worker visa. The government asserts that these changes are part of a wider strategy to manage migration and to ensure that permanent settlement is a status that is earned over a more extended period. However, it is crucial to note that these proposals are not yet law. The white paper has confirmed that a public consultation will be held later in 2025 to discuss the specifics of the ILR extension before a final decision is reached. While some other changes to immigration rules are set to be implemented sooner, the extension of the ILR route is subject to this further discussion. The proposed changes have been met with a significant public backlash. An official Parliament petition titled, "Keep the 5-year ILR pathway for existing skilled worker visa holders," has garnered substantial support, with over 156,000 signatures. Having surpassed the 100,000 signature threshold, the petition is scheduled for a debate in Parliament on September 8, 2025. This strong response underscores the widespread anxiety and concern among a diverse range of people affected by the proposal. Members of Parliament have begun to question the government on the details of the plan. However, official responses have largely reiterated that the specifics, particularly concerning any transitional arrangements for those already in the UK, will be determined following the upcoming consultation. This lack of immediate clarity has left many current visa holders in a state of distressing uncertainty about their future in the country. Currently, the majority of migrants on a work visa, such as the skilled worker visa, can apply for ILR after 5 years of continuous residence in the UK, provided they meet certain requirements, including salary thresholds and not having spent more than 180 days outside the UK in any 12-month period. The new white paper introduces the concept of an earned settlement system. Under this proposed framework, the default pathway to ILR would be 10 years. The government has suggested that there may be opportunities for individuals to shorten this period by accumulating points based on their contributions to the UK's economy and society. However, the government has not yet provided any concrete details on how these points could be earned, the extent to which the qualifying period could be reduced, or, crucially, whether individuals already on a 5-year route to ILR will be permitted to complete it under the existing rules. The government has clarified that some groups will be exempt from the new 10-year rule. These include spouses and civil partners of British citizens, victims of domestic abuse, and individuals with post-Brexit residence rights under the EU settlement scheme, who will all retain a 5-year path to settlement. One of the most pressing questions for many is whether these changes will apply retrospectively to those already living in the UK on a 5-year ILR track. The technical annex accompanying the white paper suggests this is a possibility, stating that a number of those currently in the UK are likely to leave due to it taking longer to gain settled status. News outlets, including the BBC and the Financial Times, have also reported, based on government sources, that the new rules are likely to apply to existing migrants, although there may be some exceptions for those nearing the end of their qualifying period. Until official guidance is published, this remains a significant source of anxiety for many. For those who may be affected, particularly skilled worker visa holders, the proposed changes could have serious consequences. A longer route to settlement would necessitate more frequent visa renewals, each incurring application fees. The immigration health surcharge would also need to be paid for a longer duration, adding a significant financial burden. Many individuals also rely on legal advice for their applications, further increasing the overall cost. For families, a prolonged qualifying period could lead to extended separations from loved ones overseas. Changes to the ILR qualifying period are typically made through updates to the immigration rules. These changes can be implemented automatically unless a motion to disapprove them is passed in either the House of Commons or the House of Lords within 40 days. However, the government is not obligated to schedule a debate or vote, even if there are objections from MPs. This means that, in practice, significant changes can be made with limited parliamentary debate, as was seen with major visa rule changes in 2024. Critics of the proposal argue that extending the path to ILR could deter highly skilled migrants from choosing the UK, potentially leading to a talent drain in vital sectors like healthcare, technology, and engineering. Furthermore, the emotional and psychological toll on families facing prolonged uncertainty and separation cannot be underestimated. The ambiguity surrounding the earned settlement system also raises ethical questions about how contributions to society are valued and measured. The government's promise of a consultation later in the year offers a crucial opportunity for affected individuals and organizations to voice their opinions and potentially influence the final policy. The significant number of signatures on the parliamentary petition has already ensured that the issue will be debated by MPs, increasing the pressure on the government to address the widespread concerns. The future of the 5-year ILR route remains uncertain. The coming months will be critical as the government proceeds with its consultation and weighs the feedback from migrants, families, and businesses who have a significant stake in the outcome.